Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update on Chief Minister Arvind Kejriwal's application to consult his doctor from jail. Special Judge Kaveri Baveja of Rouse Avenue Courts today rejected the application moved by him to consult his doctor through video conferencing daily for 15 minutes with respect to his acute diabetes and fluctuating blood sugar level. Kejriwal had also sought to allow his wife to join and remain present on VC. The court, while denying the request, said that in case Kejriwal requires special consultation in jail, the Tihar jail authorities shall consult the medical board to be constituted by Director of AIIMS, which will decide about administration of insulin and will prescribe a diet and exercise plan for Kejriwal. The court also clarified that he could have home-cooked food provided the same is as per the diet prescribed by the medical board. Kejriwal has been arrested by Enforcement Directorate in the alleged Delhi liquor policy scam. His judicial custody is expiring tomorrow. Stay tuned. The Supreme Court bench comprising CJI D.Y. Chandrachud and Justice J.B. Pardewala today allowed an urgent plea for terminating the pregnancy of a 14-year-old minor rape survivor. While exercising its powers to do complete justice under Article 142, the court directed the Dean of CN Hospital, Maharashtra to undertake the medical termination of the 28 weeks pregnancy. The petition has been filed by the mother of the minor challenging Bombay High Court's order, which had declined to grant the said relief of termination. The minor was allegedly subjected to sexual assault and FIR under IPC and POCSO Act has been registered in this regard. Last week, the bench had held a special sitting and had directed for medical examination of the victim so as to know the possible mental and physical impacts on the minor in the event of allowing such a termination. The bench today took note of the fact that the medical board, which freshly examined the minor rape survivor, clearly opined that continuation of the pregnancy could impact the physical and mental well-being of the minor. Thus, it set aside the Bombay High Court's order and observed that while allowing the termination at the present stage would pose fewer risks to the life of the minor than in continuing the pregnancy term till its very end. The state was directed to bear the expenses towards the procedure and safety of the minor. Any aftercare post-termination for the minor will also be given to the minor to recover fully. For your information, let me tell you here that the recent amendment of 2021 to the Medical Termination of Pregnancy Act has pushed the upper limit for termination of 20 weeks of pregnancy to 24 weeks for certain categories of women, which will be defined in the MTP rules. These categories will include vulnerable women, including rape victims. In another important update, the Supreme Court today reserved judgment on a batch of petitions challenging enrollment fees charged by different state bar councils as exorbitant. Last year, the Supreme Court had transferred to itself the petitions pending in various high courts on this issue. A bench comprising CJI Chandrachud and Justice J.B. Pardewala heard the matter today. The main point raised by the bench during the hearing was whether the bar councils can charge anything more than the amount prescribed under the Advocates Act 1961, which is Rs 600 for State Bar Council and Rs 150 for the Bar Council of India. The bench noted that there was no uniformity in the fees charged by different state bar councils. In some states like Kerala, Maharashtra, Delhi, etc., it is in the range of 15,000 rupees, whereas in states like Orissa, it is 41,000. Senior advocates Manan Kumar Mishra and S. Prabhakaran, appearing for the Bar Council of India, submitted that the state bar councils incur several expenses for welfare measures of the advocates. They submitted that contributions towards the welfare funds and expenses are collected upfront from the advocates at the time of enrollment. Senior advocate R. Basant, appearing for the petitioners challenging the enrollment fee, submitted that the bar councils cannot collect the amounts over the statutory prescribed fee under the guise of contributions for welfare measures. He argued that this would amount to creating entry barriers for young lawyers who are yet to start earning. If the bar councils need to raise money for their funds, they can charge the advocates after their enrollment, but it cannot be charged as a condition to admit lawyers to the bar. During the hearing, Advocate Vrinda Bhandari cited the example of a person belonging to the denotified community who had to run a private crowdfunding campaign to raise the enrollment fee of Rs 15,000 for enrollment at the Madhya Pradesh Bar Council. While reserving the judgment, CJI said that the Parliament has also to amend the Advocates Act to ensure funds for the bar councils. The Supreme Court has issued notice in a petition challenging inaction on the part of the West Bengal Governor Dr. C.V. Anand Bose in giving assent to West Bengal University's amendment bill. The bill was passed by the state legislature in June 2022. The court has sought a response from the Principal Secretary of the Governor of West Bengal, the Union, as well as Principal Secretary of the Department of Higher Education in this regard. The Himachal Pradesh High Court has issued a notice to BJP Rajya Sabha MP Harsh Mahajan in a petition filed by Congress leader and senior advocate Abhishek Manu Singhvi. The petition effectively challenges his defeat in the Rajya Sabha polls in February this year. He has challenged the returning officer's decision to declare the winner through a draw of lots and has questioned the election officer's interpretation of the drawing of lots in cases of a tie in Rajya Sabha polls. While issuing a notice to the BJP Rajya Sabha MP, Justice Ajay Mohan Goyal posted the matter for further hearing on 23rd May. Let me tell you here, on 27th February this year, Singhvi lost to BJP's candidate Harsh Mahajan, despite both of them getting an equal number of votes, that is 34-34 each. Mahajan's win was determined by the decision of the Chief Electoral Officer, who served as the returning officer, to conduct a draw of lots according to Rule 75 of Conduct of Election Rules of 1961. Now, this rule deals with counting votes when only one seat is to be filled. It says where two or more candidates have the same number of votes which are credited the same value, then the returning officer shall decide by lot which of them shall be excluded. Singhvi's and Mahajan's names were written on separate slips and placed into a box in the presence of polling agents and the candidates. A slip containing Singhvi's name was randomly drawn from that box. Consequently, Singhvi was eliminated from the selection process and the returning officer declared BJP's Mahajan as the winner. Challenging the returning officer's decision, Singhvi has moved the High Court. Singhvi's contention is that the decision defies common sense, old tradition and practices, because whenever there is a tie between two people, the person whose name is drawn should be the winner and not the loser. Coming to an update on the Lakhimpur Kheri case. The Supreme Court, while hearing Ashish Mishra's bail plea in connection with the incident, today observed that the public prosecutor and the local police need to take effective steps to ensure the presence of witnesses during his trial. You are already aware that Ashish Mishra, son of Union Minister Ajay Mishra, is involved in the case related to Lakhimpur Kheri violence of 2021, where allegedly his convoy ran over a group of protesting farmers, leading to death of 5 people. Previously, the Supreme Court, while deciding to keep his regular bail application pending, had granted him interim bail for 8 weeks, which is being extended from time to time. The bail has been granted with certain conditions. Notably, during the hearing today, Advocate Prashant Bhushan, appearing for the victims in this case, appraised the bench that Mishra had been participating in various political functions recently, thus violating the bail conditions. Though the argument was fervently opposed by Mishra's counsel, Senior Advocate Siddharth Dave, but the court took a firm view and orally asked Bhushan to file his affidavit in this regard. Justice Kant also expressed his concern about the examination of witnesses after noting that certain witnesses were not present for examination, which resulted in prolonging the trial. The bench thus directed the public prosecutor and the local police to take some effective steps to ensure the presence of witnesses. The court also asked Uttar Pradesh's Senior Additional Advocate General to take necessary action in this regard. The Supreme Court today refused to entertain a petition seeking to allow a 3-year LLB degree course right after 12th standard. The petitioner submitted that the students can easily study 15 to 20 subjects in 3 years, that is 6 semesters. Therefore, the present duration of 5 years, that is 10 semesters, is unreasonable and the inordinate duration is irrational. The petitioner submitted that the 5-year duration for the LLB course after school affects girl students and poor children. However, the bench comprising CJI Chandrachud and Justice J.B. Pardewala expressed disinclination to entertain the matter. The CJI said that even 5 years was too less, as more mature people are needed to come into the profession. The petition sought direction to the Centre and Bar Council of India to form an expert committee to ascertain the feasibility of starting 3-year Bachelor of Law course after 12th standard, like Bachelor of Science, Bachelor of Commerce and Bachelor of Art courses. But after the bench expressed disinclination to entertain, the petitioner chose to withdraw the petition. In another update, the Supreme Court today allowed an appeal filed by Yash Films against an order of National Consumer Dispute Redressal Commission. The NCDRC had imposed a penalty on them regarding a song in the 2016 Shah Rukh Khan starrer movie titled Fan. So the song was shown in the promos and the teasers but was not included in the movie. The question here was whether a promo or a teaser which has been circulated before the release of a movie creates a contractual obligation and whether it is an unfair trade practice to not show contents of the promotional trailer in the movie. The complainant in the matter, Afreen Fatima Zaidi, had filed a consumer complaint against the Yash Raj Films, complaining that she was cheated on account of the song Jabra Fan, which was shown in the promos and trailers of the film Fan, but not being shown in the film. She stated that her children refrained from eating on the evening they went to watch the movie because they were disheartened by the absence of the song in the film. This led to an increase in their acidity levels and subsequent hospitalization. The NCDRC had affirmed the State Commission's 2017 directive to pay 10,000 rupees in compensation to her. Against this, the appeal was filed before the Apex Court, which has now been decided by a bench of Justices P.S. Narasimha and Arvind Kumar. The appellant, YRF, contended that NCDRC's order infringes upon its fundamental rights as it imposes unjust conditions on how it conducts its professional activities. The Supreme Court has allowed their appeal. For more details, you can visit livelaw.in. And now coming to a short update on the case filed by Karnataka government against the Union of India for drought relief funds. The state has alleged that centre was denying it financial assistance for drought management under the Disaster Management Act of 2005 and the Manual for Drought Management. It was highlighted that under law, the central government is required to take a final decision on assistance to the state from the NDRF within a month of receipt of the interministerial central team. However, that period was over in December 2023. In this regard, a bench of Justices B.R. Gawai and Sandeep Mehta was today informed by the Attorney General R. Venkata Ramani that the Election Commission has given clearance to centre to deal with the issue. As Senior Advocate Kapil Sibal, appearing for Karnataka, raised no issue in light of confidence shown by the AG, the hearing was then adjourned to next week. The Supreme Court today issued notice in an SLP challenging bail of 4 accused convicted in the 2008 murder case of journalist Somya Vishwanathan. The bench of Justices Bela M. Trivedi and Pankaj Mittal heard the matter. For those of you who might not know, Somya Vishwanathan was a 25-year-old journalist who was shot dead in September 2008. She was returning to her home from work in her car late in the night when the tragic incident took place. 4 persons, namely Ravi Kapoor, Amit Shukla, Baljit Malik and Ajay Kumar, were awarded double life imprisonments by the special court in the case last year, that is, more than 15 years after Somya was killed. They were convicted for the offence of murder under IPC as well as for committing organized crime under Maharashtra Control of Organized Crime Act. Following this, the convicts moved to the Delhi High Court challenging their conviction and sentence of life imprisonment. They had also filed applications seeking suspension of sentence during the pendency of their appeal. Noting that convicts had undergone around 14 years of incarceration, the High Court had allowed these applications. Let me tell you, out of the 4 convicts in question, Ravi Kapoor, Amit Shukla and Baljeet Malik were also convicted in the 2009 IT professional Jigisha Ghosh murder case. Later, they had disclosed to the police during cross-examination that they had also shot dead Somya. The Delhi police claimed that the motive behind her murder was robbery. And lastly, the Delhi High Court today dismissed a PIL seeking release of Chief Minister Arvind Kejriwal on extraordinary interim bail in all the criminal cases registered against him, including the Enforcement Directorate, which are pending for inquiry or trial till the completion of his tenure. The PIL was filed by a 4th-year law student under the name We the People of India. Citing examples of killings of gangster Tillu Tajpuria and Atiq Ahmed in custody, the PIL stated that Kejriwal's safety and security in the Tihar jail was in danger. The petitioner also was ready to extend personal bond in favor of Kejriwal to undertake that Kejriwal will not influence witnesses. A division bench comprising Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora said that the petition was not maintainable as Kejriwal was in judicial custody and had the means to approach the court and file appropriate proceedings. The court also said allowing the petition would mean that there should be no undertrial in custody. Observing that the petition was meant for publicity, the court also imposed a cost of 75,000 rupees. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.